Welcome, everyone. We're jumping straight into some really interesting material today. We're looking at House Resolution 1526.
That's right, also called the No Rogue Rulings Act, or NORRA of 2025.
Yeah, NORRA. It's passed the House. Now it's over in the Senate Judiciary Committee. And hey, if you find this kind of discussion useful, please do hit those like and subscribe buttons. It really helps other people find us.
Absolutely. And our goal today is really to unpack this thing. It's a proposed change to Title 28 of the U.S. Code. So what's it trying to do? Why? And, what might the effects be on the courts and legal challenges?
Well, let's get to the core of it. Okay, starting point. Title 28 U.S. Code. Sounds pretty foundational. What is that exactly?
It really is the bedrock, yeah. It's basically the rule book for the entire federal court system.
The whole thing, like how courts are set up.
Exactly. The structure, Supreme Court, appeals courts, district courts, but also crucial things like jurisdiction, which court can hear which case, and venue where you can file a lawsuit, procedures too.
Okay, so it covers a lot.
It does. It's divided into 6 main parts, covering everything from the courts themselves, the Department of Justice, court staff, procedure. But the key part for us is Part 4.
Part 4, why that one?
Because Part 4 deals with jurisdiction and venue. And that's precisely what House Resolution 1526 is aiming to amend.
Ah, okay. So it's targeting the rules about which courts have authority and where cases can be brought.
Precisely. It wants to add a new section, Section 1370.
1370.
Yep, right into Chapter 85 of Part 4, which is all about the jurisdiction of the district courts, the main federal trial courts.
So the focus is clearly on those trial courts. What's the big change this new Section 1370 would make?
Well, at the absolute heart of it is limiting the power of those district courts to issue injunctions.
Injunctions. Those court orders telling someone to stop doing something or sometimes to do something.
That's the one. And the key bit of the proposed law, Section 1370A, says, let me paraphrase slightly. Basically, no district court can issue an injunction except one that only applies to limit the actions of a party in the case concerning the specific person seeking the injunction.
Okay, let's simplify that. It sounds like it's trying to stop a single judge in one district from issuing an order that affects the whole country.
That's exactly it. It's aimed squarely at preventing these so-called nationwide or universal injunctions.
Where one judge can block a federal law or policy everywhere for everyone, even people not in the lawsuit.
Right. Under this proposal, the relief the injunction would generally only apply to the specific people or groups actually in that specific court case.
So what's the argument for doing this? Why limit these nationwide injunctions?
The main argument from supporters is about tackling what they see as judicial overreach.
Overreach?
Yeah, or sometimes even framed as judicial tyranny. The concern is that one single unelected judge can effectively halt a policy made by the elected branches of government across the entire country.
Acting like a national policymaker from the bench. Is that the idea?
That's the core concern they raise, yes. They argue it disrupts the balance of power. And the name itself, No Rogue Rulings Act, definitely signals that intent to stop what they see as judges going beyond their proper role.
But I imagine others would argue that's precisely the judiciary's role sometimes, to provide a check, even a nationwide one, if rights are being violated.
Oh, absolutely. That's the other side of the debate, whether this limits a necessary check on executive power.
Okay, so it limits injunctions generally. Are there any situations where a broader injunction could still happen under this proposal?
Yes, there's a significant exception built in. It applies if a challenge to an executive branch action is brought by at least 2 states.
2 states.
2 or more states. And critically, they have to be located in different federal circuits. So say California and New York, or Texas and Florida.
Okay, states from different regions, essentially. What happens then?
In that specific scenario, the case wouldn't go to a single judge initially. It would go to a special 3-judge panel.
A 3-judge panel. How would they be chosen?
The law says they'd be selected randomly, not appointed by the chief judge of the circuit, which is how it often works now for these panels.
Interesting. And this panel, could they issue a broader injunction?
Yes, that's the key. This 3-judge panel would have the power to issue the kind of broader injunctive relief that the bill generally prohibits for single judges.
So presumably under certain conditions.
Right. They'd have to weigh specific factors: the interest of justice, the risk of irreparable harm to non-parties, people not directly in the lawsuit, and the preservation of the constitutional separation of powers.
So a higher bar, considered by 3 judges instead of 1, and appeals from that panel, where would they go?
Appeals could go straight to the Supreme Court, or alternatively to the relevant Circuit Court of Appeals. The party appealing gets to choose which path.
Okay, this really could change the landscape for challenging federal policies. What kind of ripple effects are we talking about if this becomes law?
Well, several things. First, litigation strategy would almost certainly change.
How so?
If you can't easily get a nationwide injunction from one court, groups wanting to challenge a policy might have to file, multiple lawsuits in different districts around the country.
Trying to get lots of smaller, geographically limited injunctions instead of one big one.
Exactly. Patchwork relief, potentially. It could become much more fragmented.
Seems more complicated, maybe more expensive for challengers.
It could well be. Another potential shift is lawyers might focus more on a different legal tool seeking vacatur of an agency rule under the Administrative Procedure Act.
Vacatur, meaning?
Basically asking the court to declare the rule legally invalid and throw it out completely. Not just stop its enforcement temporarily with an injunction, but nullify it. That would have a nationwide effect.
Ah, I see. So a different path to a similar nationwide outcome.
Potentially, yes. And then there's the big picture debate about separation of powers. Supporters say NORRA restores balance by curbing judicial power.
While opponents would say,
Opponents argue it weakens the judiciary's vital role as a check on the executive branch, potentially making it harder to hold the government accountable quickly on a national scale.
and what about the money side? Did the Congressional Budget Office weigh in?
They did. The CBO said the bill could have significant budget effects, but they couldn't really put a number on it.
Why not?
Because it's hard to predict, right? Injunctions can stop or delay policies that cost or save money. Predicting future lawsuits, how judges will rule, and the financial impact of those rulings, it's just too uncertain.
Makes sense. So thinking about who might favor this change versus who might not. Who stands to gain?
Well, potentially the executive branch, whichever party is in power. It might be easier for them to roll out policies nationwide without facing an immediate stop sign from a single judge.
Okay.
Also, maybe supporters of specific federal policies that might otherwise be challenged, and generally those who think the judiciary's role should be more constrained.
And on the flip side,
Yeah.
who might see downsides?
Individuals, advocacy groups, maybe even states that want to challenge federal actions quickly and broadly. They might find it harder, slower, more resource-intensive.
The tool of the nationwide injunction becomes less available.
Exactly. Some might also argue the judiciary itself loses some authority, some ability to provide that immediate, broad check. And groups that have historically relied on these injunctions, perhaps for civil rights or environmental protection, might find a key strategy less effective.
Okay, so just to remind ourselves, where is House Resolution 1526 right now?
It made it through the Vice of Representatives, passed largely along party lines, which tells you something about how contentious it is.
And now?
Now it's sitting with the Senate Judiciary Committee. They'll decide whether it moves forward in the Senate.
So the bottom line seems to be this No Rogue Rulings Act is a pretty significant proposal aimed at changing how federal courts, specifically district courts, can issue injunctions, especially those big nationwide ones.
That's the core, yes. It's really about the scope of judicial power when it comes to nationwide policies, and it plugs right into these ongoing arguments about checks and balances and the separation of powers.
Definitely gives you something to think about. How would this change things for people or states trying to challenge the government, and what new legal tactics might we see if this actually becomes law? Lots to consider there. Thanks for walking us through all that.
My pleasure.